Having been in this situation, I think it's 6 days after decision, it's sort of hard to avoid relitigating a case, but I certainly want to focus on what the immediate effects of this decision were. Like my colleague, Sherilyn Eiffel, who is stuck in one of the stages of grief, my initial reaction to Shelby was that our stages of celebration, I don't know if those have been laid out by psychologists yet, but our stages of celebration of the decision in the Arizona case 8 days before was interrupted by Shelby coming down. The Arizona decision, of course, concluded that Arizona's voter registration documentation of citizenship requirements were preempted by the National Voter Registration Act, which was something we had worked over many, many, many years, as well as the Lawyers Committee to get that ruling. And it highlights what I think are some of the critical initial effects of Shelby County. From the perspective of the Latino community, 2 of the covered states are of particular significance in this day and age, and they are Arizona and Texas. Texas has, I think, probably consumed in MALDEF's 45 years of existence, consumed more of our energies in litigation than any other jurisdiction in the country, not only in voting, but in education, in employment, in immigrants' rights, you name it. And particularly in voting, it has consumed much time and litigation in recent years. And the immediate effect of Shelby was with respect to 2 pending changes in the state of Texas under Section 5 that had not been pre-cleared and that were before the Supreme Court, having come out of the district court here in Washington, one dealing with redistricting, the other dealing with a voter ID provision that had been enacted in 2012 but blocked from taking effect. Obviously, both of those cases are now making their way very slowly back to the district court where they will be dismissed, but there has already been action taken under Section 2, one preceding this case and one filed almost immediately after with respect to those 2 provisions. A Section 2 case was filed against the voter ID provision. Obviously, that's a much more difficult means of challenging what would, we believe, quite seriously depressed and deterred voter participation in Texas had it taken effect when it was enacted. With respect to redistricting, despite the immediate pronouncements from the Attorney General about both of these changes in Texas, a day or 2 after the Shelby decision was handed down, Governor Perry signed a new redistricting map, one that looks dramatically different from the initial map adopted by the legislature that was not pre-cleared and that was pending before the court. That map in part came about because there was already pending Section 2 litigation about the redistricting map that had been adopted and not pre-cleared under Section 5. Texas is obviously the largest jurisdiction that was covered by Section 5 until this decision. It has a number of sub-jurisdictions. We are constantly trying to keep apprised of the changes that may be being put in place in those sub-jurisdictions, and that's certainly one of the significant concerns coming out of Shelby's aftermath. Arizona is another state of great concern to the Latino community, and I should say why I think in this day and age these are of particular concern. These are both states with significant and growing Latino populations, including significant growth in the voter-eligible population in both cases. In both cases, those numbers are growing to an extent that they begin to threaten very well entrenched political interests, because by and large, with the growth of the Latino vote, it has not been a vote in support of the continued policies that have prevailed in those 2 states. And this is the kind of situation where I think efforts to suppress the vote, efforts to deter participation, are particularly likely and particularly dangerous, where you have large jurisdictions with growing minority populations, and those growing minority populations and their participation present some threat to well-established and entrenched political interests. That's where we ought to be particularly concerned about what might occur in the realm of deterring voter participation. And Shelby's removal of Section 5 as a built-in protection against that very likely political phenomenon is a matter of grave concern, and one that I think is worthy of significant attention and why I'm pleased that we're having this conversation today.